go forward with the sentencing in the Jake Haro matter. Again, announcing to the public there are no use of cell phones, no recording except for the pool camera. There will be no comments about the case while the court is in session, no outbursts, and please follow the instructions given by our RSO deputies. With that, calling the matters of Jake Haro. Appearances, please.
Thank you. Paulette Garthwaite for Mr. Haro. He is sitting right next to me at council table. And thank you, Your Honor. Good afternoon. Allison Lowe also on behalf of Jake Haro.
Good afternoon, Your Honor. William Robinson for the people.
Good afternoon.
Let me fix the volume, guys.
Thank you. And good afternoon, Mr. Haro. And this is the time and place set for sentencing. Are both sides ready to go forward at this time?
Yes.
And the court has read and considered the sentencing memorandums provided by Ms. Garthwaite and Ms. Lowe, as well as Mr. Smith and Mr. Robinson, as well as the probation report. At this time, does either side want to be heard further? Mr. Smith, Mr. Robinson, any victim impact statements for the court to consider?
There will be no victim impact statements. No.
Okay. And Ms. Garthwaite, Ms. Lowe?
Your Honor, I just wanted to very briefly reiterate the defense objection to imposing court fees and fines. Mr. Haro is indigent. He's a public defender client. I believe that the court is going to sentence him to a lengthy sentence. And prior to his arrest, he was unable to work and was receiving disability.
Oh,
So
poor
we would
guy.
object to
The baby
court
murderer.
imposing any court fees and fines. If the court is going to assess a restitution fine, it is based, or the defense requests that based on the indigency, that the court set it no higher than $300, which is the minimum.
Okay. And Mr. Smith, Mr. Robinson, do you want to be heard in regards to that?
Yes, I'd say that while I intend to submit in large part on the sentencing memorandum I filed with the court, I do want to reiterate that while I understand the court has some discretion in this matter regarding the sentence and the fines and fees, I want to emphasize the fact that this defendant deserves no leniency.
Right.
In any regards, as to sentence or as to fines and fees. The court is well aware of how this case began with the defendants standing in front of law enforcement and the public and creating this public panic about a child being kidnapped, and the resources that were expended in order to investigate those lies of the defendant need to be addressed in this sentence as well. So I would ask that the court recognize that in deciding how much to assess the defendant in fines and fees, as well as in exercising its discretion regarding the appropriate sentence in this case.
Thank you, Mr. Smith. Anything further before the court begins its sentence?
No, Your Honor.
I'm sorry. Yeah, so I'm sorry, we've had, a change of opinion. So the Emmanuel Haro's grandmother has now asked to address the court about the sentence.
Oh, victim impact.
Okay.
The grandmother's going to talk. Let's everybody welcome. No notifications. Baby killers being sentenced. Jake Haro. They made up the whole fake story of kidnapping and all this insanity.
Hello, ma'am. And Mr. Smith, if we can have an introduction, please.
Yes, so this is Emmanuel Haro's maternal grandmother. Her first name is Mary, M-A-R-Y. And I'll have her spell her last name.
B-U-S-H-A-U-S-E-M.
Good afternoon, ma'am, and thank you for being here today. And ma'am, I want to make sure that I hear everything that you have to say, that our court reporter can take down everything that you have to say, and that we have an accurate record. We've cleared our entire afternoon, so you don't feel the need to be rushed. So whenever you're ready, if you could speak loudly and clearly and slowly for us. But whenever you're ready.
I want Jake to look at me. I I want him to face me.
Ooh.
And ma'am, if you can address the court.
I would like for him to face me, to look at me.
Yeah, turn around.
Okay.
She's asking. She's asking too. Yeah, turn around. Turn your punk ass around.
And Nana, if you could speak up as loud as you can, please.
I wanted Jake to face me, to look at me, because I told him that I would be here for his sentencing before he was arrested. I talked to him about, as a friend, to tell me everything, because he didn't give me the opportunity to meet my grandson. He destroyed my whole family. He branded his children for life. He damaged her children, all his children for life. And in doing that, he destroyed my family, my children, everybody in my family. All my children are destroyed by this. He changed my daughter to where we don't know who she is. He never gave me a chance to see my grandchildren. He kept my daughter away. I don't know what he did or how he changed my daughter's life. But she was never that same person after she went to live with him.
I think she
The
should
only reason
that heifer.
Rebecca came back, because in March I had a stroke. And my son got hold of her and told her I was in ICU. That's how I met Mackenzie, my 2-year-old granddaughter. I didn't even know she existed. Because I was not aware that she was pregnant with Mackenzie. I was not aware that she was pregnant with Emmanuel. I never met Emmanuel. You know, he deprived everybody. And it has hurt my children because the media has torn all of my children apart, okay? Because they say, Grandma knows, Grandma isn't on it, Grandma doesn't know nothing. If I had known what was going on, I would have take my daughter out of there forcefully, or I would have called the police. My sons would have come and got her, okay? Never did we ever knew anything. If I had known when I called social service when Rebecca moved in, I called social service to let them know that I didn't like him. That because my granddaughter Irene was afraid. She didn't want to be there. She called me and she says, Grandma, I don't want to be there. Okay, so I called social service. I asked social service to give me a report of what had happened, they found out. Oh no, she's fine, the house is beautiful, they have food in the fridge, that's it. Had social service come and told me what he had done to promise his other children. Nothing of this would be here. We wouldn't be here, I wouldn't be here. My grandchildren, Emmanuel wouldn't be gone, Mackenzie wouldn't have been born, because he had already done a lot of horrible things to his other children. He branded those children for life. And in the same way, branded all my children too. Because I can't go nowhere without they asking me. Every time I go to the store or somebody recognizes me, they attack me, you know? On social media, everywhere. And that is not my doing. Or my children. This has been horrible for us. I was glad the day that got arrested because I fear for my daughter's life, I fear for everybody. And you know, he had a second chance. My daughter didn't have a chance with him. Or his children. His children didn't have a second chance. And I think the judge that let him go should be here sitting with him. And so is social service. Because they could have told me, oh no, protocol doesn't allow us to tell you anything. Well, how are we supposed to protect our children if we don't know? The court knows what's going on. I didn't know. I called social service. I didn't know what he had done to his other children. And here he sits, you know, like nothing. Somebody will give him another chance. And I don't want that. Because he didn't give his children a chance. He didn't give my daughter a chance to be happy to take care of her children, okay? My 20-year-old granddaughter, my 18-year-old granddaughter are a mess because of him. Mackenzie, it's totally changed, a little baby, a 3-year-old girl that has nothing, okay? I'm very, very stressed out, very angry at the justice system for letting this guy, giving him a chance. Who gave my grandchildren a chance, a second chance? Did CPS check? Why didn't they tell me? Oh look, this is what that guy does. He takes it out on the children, on the baby. He can't do it to a grown person. He's not man enough to do it to a man, okay? He destroys so many lives. His mom, his brother, everybody, okay? Nobody wants to be here. Nobody wanted to come and look at it. But I had to speak for my grandson and my grandchildren, and for my children too, because they're going through every hell in this world, okay?
Thank you, Mom.
I didn't mourn my grandson that he passed away. We buried him on the 5th of August, and they were saying that, oh, we probably bury Emmanuel in my grandson's, when we bury my grandson, okay? I lost my grandson on the 5th. We buried my grandson on the 5th of August. Then he calls me on the 14th of August and says that Emmanuel is kidnapped. And then my sister passes on the 17th of August. We didn't have a chance to mourn any of my sister, my grandson, my other grandson, none. Because everybody was angry at everybody because how could this happen? Why? I wish you could look at me and tell me why. He was never in my house. He knew I didn't like him. He knew I called social service, and that's why he kept my daughter away. He changed her so she couldn't have no contact with me or his brothers, okay? Had I not had a stroke, I would have never met Mackenzie or, you know, probably heard it on the news about Emmanuel, okay? So don't blame my children. The media has blamed my children, everybody. The TikTokers, everybody.
TikTokers.
Grandma Mary knows. I don't know nothing, okay? And I stand here with you, asking you to give him the maximum. Because I don't want him to give him another chance. He didn't give nobody a chance. He had many chances. He had a chance. The judge gave him a second chance. The probation gave him another chance. The CPS, oh well, you know, no, he's fine. He's got food in the fridge and the house is clean. That doesn't cut it, okay? And that's not fair to the children to let somebody out like that. And I'm sorry, Your Honor, I'm just very, very upset and very stressed out.
And ma'am, no need to apologize. This proceeding here is for you to make your impact statement to talk about how the crime has affected you and your family. I do want to lead with, I'm sorry for your loss. I'm sorry for all the hurt that you and your family have gone through.
A lot of hurt.
And I want to thank you for being here today.
I'm here because I'm the only one that wanted to be here, because my children don't trust themselves to come in and talk because they're so upset, so angry at this system, what they did. How could they give him a second chance when you see the pictures of the little girl? How?
Yeah. Little girl, I think she's blind.
That's beyond me. You know, you get two drunk driving tickets and you go to jail or you pay a goddamn fine. And he, a slap on the hand, go and do community work. Okay? How does that happen, Your Honor? I want to know how did that happen.
Anything else, ma'am?
No. Thank you, Your Honor.
Thank you. Mr. Smith, Mr. Robinson, any other impact statements on behalf of the people?
No, thank you.
Ms. Garthwaite, Ms. Lowe, no impact statements on behalf of the defense?
No, thank you, Your Honor.
And submitting on your motion?
Yes.
Submitting on your motion.
Yes.
So the court is now going to pronounce judgment at this time. Ms. Lowe, Ms. Garthwaite, Mr. Robinson, Mr. Smith, are you okay if I sentence on all three together, all three cases?
Yes.
Yes.
This time, this court, having taken the defendant's plea, having read and considered the probation report, and having seen, heard, and considered the evidence and arguments of counsel at the sentencing hearing, as well as taking judicial notice of its own records, hereby pronounces the sentence as described in this order. The court imposes an aggregate sentence of 180 days and 6 years, 8 months, plus 25 years to life and fines as specified. As I will explain shortly, the sentence of 180 days and 6 years and 8 months will be determinate. The 25 years to life is indeterminate and will be described at this time. Probation is denied. Because Mr. Haro was on probation for a felony offense at the time he committed the serious and violent offenses of murder and assault on a child underage causing death, he is ineligible for probation pursuant to Penal Code Section 1203. Accordingly, probation is denied.
Shaking his
In
head.
regards to the terms of imprisonment, this case involves the imposition of determinate terms and indeterminate terms. The court will first address the indeterminate terms. I did read the briefing submitted by Ms. Lowe and Ms. Garthwaite, as well as by Mr. Smith and Mr. Robinson. For count 1, in case FERI 2504-808-1, murder in the second degree, the court imposes the only term provided by law of 15 years to life. The court notes that the amended complaint filed by the people lists the punishment for count 1 as 25 to life, which would suggest that the charge is first-degree murder, but we did have a discussion at the last hearing regarding those sentence or that charge, and that is in the second degree. So I want to make sure that that's clear, Mr. Smith and Ms. Lowe.
Yes, Your Honor.
Accordingly, the court orders the designation of the 25 to life stricken from the amended complaint. For count 3, in case FERI 2504-808-1, assault on a child underage causing death, the court imposes the only term provided by law of 25 years to life. The court finds that counts 1 and 3, in case ending in 808-1, are based on the same act. An act or omission that is punishable in different ways by different provisions of law may be punished under either of such provisions, but in no case shall the act or omission be punished under more than one provision. Accordingly, the court stays the punishment for count 1, the murder charge, pursuant to section 654. The court declines to state a punishment for count 3 instead of count 1, pursuant to section 654. Mr. Haro, through his attorney, urges the court to stay the higher punishment because he acknowledged wrongdoing and pled guilty at an early stage of the criminal process, which is a mitigating factor under the rules of court. And the court does not find this to be a compelling reason to select the 15-year to life term in lieu of the 25-year to life term. While Mr. Haro did plead guilty at an early stage in the proceedings, this does not outweigh the significant and considerable aggravating factors that he has admitted to. It cannot be ignored that Mr. Haro was on probation for severely abusing one child when he decided to assault and kill another child. Further, the court notes that Mr. Haro was out on bail in 2 cases, including one for abusing his daughter when he killed baby Emmanuel. And the fact that Mr. Haro pled guilty at an early stage, while not insignificant, cannot overcome the horrific nature of the circumstances here. Given the admissions Mr. Haro himself has made with respect to the aggravating factors, accordingly, I will impose the indeterminate term of 25 years to life. Mr. Haro has also been convicted of 3 felony charges with determinate sentences. The court selects the child abuse charge, the 273A from case BAF 2101265-2 to be the principal offense. The court orders executed the previously imposed term of 6 years, which is the upper term. As will be explained, the court orders the determinate punishments to run consecutively to the punishment imposed in felony case ending 808-1. In case BAF 2400717, Mr. Haro has pled guilty to being a felon in possession of a firearm pursuant to Penal Code Section 29800 and ammunition under Penal Code Section 3305. These offenses are based on his possession of a loaded firearm, which is a single act. Accordingly, the court stays punishment for count 2, the possession of ammunition charge, pursuant to Section 654. For the firearm possession charge of count 1, I will impose a subordinate term of 8 months, which is 1/3 of the midterm, to run consecutively to the principal term. When determining whether to impose consecutive or concurrent sentences, the rules of court provide several factors for the court to consider. The factors related to the crime include whether or not, 1, the crimes and their objectives were predominantly independent of each other. 2, the crimes involved separate acts or threats of violence. Or 3, the crimes were committed at different times or separate places, rather than being committed so closely in time and place as to indicate a single period of terrible behavior. The court may also consider any aggravating or mitigating circumstances in deciding whether to impose concurrent or consecutive sentences, except that the court may not impose a consecutive sentence based on 1, a fact used to impose the upper term, or 2, a fact used to otherwise enhance the defendant's sentence, and 3, a fact that is an element of the crime. The consecutive punishments are appropriate here because the crimes and their objectives were independent of each other, involved separate acts, and were committed at different times, indeed over the course of many years. Accordingly, the court imposes all felony punishments to run consecutively to each other. Mr. Haro has also pled guilty to a misdemeanor offense of filing a false police report in count 2 in felony case ending 808. For this misdemeanor offense, the court imposes a term of 180 days to be served in any penal institution. Having imposed the terms as explained, the court hereby imposes an aggregate term of 180 days and 6 years 8 months, plus 25 years to life in state prison. I do want to touch on my discretion in case there was any question. Looking back on this in the future, were the voters were the voters or the legislature to amend any statutes, or were there to be any decisional law in the future that would grant this court any additional discretion in sentencing and which might benefit Mr. Haro, this court would decline to exercise any such additional discretion to lower or mitigate Mr. Haro's sentence. The court has weighed and balanced all the aggravating and mitigating factors in this case and considered all circumstances such that the court believes the current sentence is just and appropriate. Mr. Haro's conduct and culpability in the offense against his own children lead the court to conclude that Mr. Haro's sentence today is fully justified without future downward modification, even should the legislature provide such discretion. In regards to the fines, the court will impose a restitution fine of $10,000. The court finds the maximum fine is appropriate given the number of felonies the defendant was convicted of and the number of years he is being ordered to serve. The court imposes the parole revocation restitution fine in the amount of $10,000 as well. This fine is stayed unless and until parole is revoked. I will impose the court security fees as well as the penalties. The court additionally imposes a state penalty of $10 for every $10 or part of $10 upon every fine imposed. The state penalty assessment of 20% of the base fine, the court operations assessment of $40 for each conviction, and the court facilities assessment of $30 for each conviction. Ms. Lowe, I will take note of your request under Duenas. And at this time, those fines and fees will be imposed, but stay the execution pursuant to Duenas. In regards to restitution, the court orders victim restitution to be paid in any amount that may be determined in the future. Mr. Haro is also ordered to pay interest at a rate of 10% per annum, accruing as of October 12th of 2018 in case BAF ending in 265, as of July 27, 2024 in BAF ending in 717, and as of August 14, 2025 in felony case ending in 808-1. Mr. Haro is hereby advised the restitution orders shall be enforceable as if they were civil judgments. Mr. Haro, I'm going to advise you of the following at this time. You are advised of your right to appeal. The notice of appeal must be filed within 60 days after the rendition of the judgment or the making of the order being appealed. You are also advised that if you are indigent, you are entitled to appointment of counsel upon request. Sir, I'm also advising you of your requirement to provide buccal swab samples, right thumbprints, and a full palm print impression of each hand and any blood specimens or other biological samples. Sir, also advising you that as a result of these convictions, you are prohibited from owning, purchasing, receiving, possessing, or having under your custody or control any firearms, ammunition, or body armor. You are also ordered to relinquish any firearms. Sir, I'm advising you, and I went over this at your plea, that if you are not a citizen of the United States, these convictions will have the consequence of deportation, exclusion from admission to the United States, and denial of naturalization pursuant to federal law. You're also advised that at the expiration of the term of imprisonment here imposed, you may be released on parole unless the Board of Prison Terms waives parole for good cause. If parole is granted, the period of parole shall be for 3 years. Now, sir, going over your credits, and Ms. Lowe, Ms. Garthwaite, Mr. Smith, Mr. Robinson, I believe we went over these this morning, but just want to make sure that I have the correct credits. Sir, in BAF, case ending in 017, you have credits of 72 plus 72 for a total of 144 days. Mr. Smith, Ms. Lowe, Ms. Garthwaite, do you agree?
Yes.
Yes.
In case ending in 265, your banning case, you have credits for 167 days actual plus 166 days 4019 for a total of 333.
Yes.
Yes.
And lastly, sir, in the case, your newest case, ending in 808, your Riverside case, you have credits of 74 days actual plus 0 days good time credit for a total of 74 days.
Yes.
So to reiterate the final disposition, Mr. Haro, you are hereby sentenced to serve 180 days and 6 years, 8 months to terminal. You are ordered to serve 25 years to life in the state prison for the child abuse perpetrated against CH for unlawfully possessing a firearm and ammunition after having been convicted of such a heinous crime, and for the senseless assault and murder of baby Emmanuel. While no sentence can possibly vindicate the loss of innocence and life at the hands of Mr. Haro, the man who was supposed to protect these precious and defenseless children against evil and harm, the sentence here is the most the court can do to ensure that as much justice is done as possible. To that end, the court imposes the aforementioned terms of imprisonment, fines, and penalties and assessments, and I will be filing a written order of today's sentence. Anything else at this time before I sentence him or order him transported forthwith? Ms. Lowe or Ms. Garthwaite?
No, thank you, Your Honor. I have a point of clarification, Your Honor.
Okay.
I just wanted to inquire, it's my understanding that the court did impose the $10,000 restitution fine that stayed that person paying us?
Yes.
Okay, thank you, Your Honor.
Mr. Smith, Mr. Robinson?
Nothing, thank
Nothing
you.
further.
Thank you. And at this time, Mr. Haro, I am going to order that you are transported forthwith by the Department of Corrections for housing in the state prison.
Well, sentence to 25
And
years
Ms.
to life.
Lowe, Ms. Garthwaite, before you leave, there was an issue that we had kicked over to today's date in regards to the violation of probation and the subpoenaed documents. Mr. Robinson, Mr. Smith, Ms. Lowe, Ms. Garthwaite, how would you like to proceed with those documents?
It's my request that that be put over to the January 21st FSC date. I did tell defense counsel for Mr. Haro that I would notify them. I'd like to address who has standing to object to those on that particular day.
And Your Honor, anytime that third-party documents are subpoenaed to the court, there's a procedure where the court has to determine if there's good cause and conduct an in-camera hearing, and that's with or without an objection. But I already did object to the release and asked that the court follow that process at the last court proceeding. If the court would like me here in January to make that same record, I'm happy to do so.
So you made the record. It was my understanding that there might be a request that those documents were not needed. So we'll continue the matter to January 21st. I'll note your objection. In between now and then, I'll review the documents for materiality. Mr. Smith, if you can let me know if you plan to continue to use those documents. If you're not going to use the documents, then I will not review them and we'll keep them downstairs. But if they are going to be released, I will review them for materiality.
Based on my limited understanding of what's in those documents, I do believe it's possible that I would like to use them, so I asked the court to review them.
Okay, so I'll review them by the next court date, and then Ms. Lowe and Mr. Smith will have further conversations, and we'll figure out, Ms. Lowe, if it's necessary for you to appear on that January 21st date, as well as you, Ms. Garthwaite. Anything else?
Yes, Your Honor, Mr. Haro has some paperwork to take back with him. And so we want to make sure, I don't think that we ever made an order that he could have paperwork transported back and forth.
I'll make an order that he be allowed to transport his legal paperwork to and from court.
Thank you.
Thank you.
Okay, court's in recess now. Can I have a step outside, please?
Camera.
Okay, so, well, on count one, he was charged with second-degree murder. Oh, I thought that we were going to see him walk out. It was 15 years to life. That's the only term allowed by law. 25 to life for that charge would have been first-degree murder. Count 3, same case, assault on a child causing death, imposes 25 years to life. Finds both counts arise from the same act or omission, punishable under only one provision. The court rejects defense arguments for mitigation, noting Haro was already on probation for abusing another child. So it was the other child he already had abused. He was on probation for that, and then he goes to kill this child. So he was already on probation and was out on bail in 2 other cases when Emmanuel was killed. Add 6 years to prior felony child abuse and 8 months for a firearm possession to run consecutively. I think it kicked me off the internet. I think it kicked me off and restarted the connection. Holy moly. All right, I'm going to head out for now, though, guys. So, yeah, 25 years to life. Crazy, crazy. Actually, should have got more, but you know, I guess that's what they could do. I don't think they're going to let him out before. All right. Take care, guys. Bye. Bloop, bloop.